Good morning. We'll be on the record in case number 24-2470. This is NZ Management Group LLC et al. Versus Sound Fusion LLC and Adrian D. Rivas. Mr. Calzada, could you turn on your camera, please, sir?
Judge, I'm trying to. For some reason, it's not allowing me, which I don't really understand why. I use Zoom all the time and never had this issue come up at all. Can you hear me, Your Honor?
Yes, sir, I can.
All right, here we go. Let's see if this is. I keep hitting start video. It's just not letting me do it. What is going on? The other option I could have is to try a different computer.
We'll stand by.
Okay, I'm gonna close this out and just operate from the an iPad. Give me just one moment, please. I apologize for this. This is unusual. I'm in on the iPad. If you'll let me in, please. Sorry about that, Judge. I don't know why that happened.
That's okay. We can see you now. All right, so we're here on a order to show cause directed at Attorney Ricardo Calzada individually why sanctions shouldn't be imposed against him for failing to follow a few of our orders. Sir, I'm going to allow you to respond to the show cause order, but I do want to lay a bit of a background. Before I do that, let me introduce the rest of the panel. I'm joined by the Honorable Jared Smith and the Honorable Rachel Kamoutsas. I'm Dan Traver, and I'm the Chief Judge of this court. By way of background, on November 14th of last year, you filed a notice of appeal in this case of a trial court order involving a final judgment on a promissory note. You filed the notice of appeal on behalf of four appellants, NZ Management Group, Inc., Luis Javier Lizardi, Nisha Peña Pantojas, and Oscar Baudilio Figueroa. The judgment was imposed against those four defendants and appellants jointly on May 8th I'm sorry, that was November 14th of 24. On May 8th of 25, after we issued some orders directed to you as to trying to figure out why the record in the initial brief hadn't been filed, you filed a suggestion of bankruptcy on behalf of the three individual appellants. You identified their pending bankruptcy case numbers in the Middle District of Florida Bankruptcy Division in that filing. 6 days later, we noted the automatic stay and directed the parties to provide a bankruptcy status within 120 days. That 120 days came and went without a status being filed, and on September 17th of last year, we ordered the debtor to file a status report within 10 days. That date came and went. On October 7th, having again received no status, we ordered you individually to file a status report on the bankruptcy proceedings within 10 days, failing which we warned you that you risked sanctions. On December 5th, again having received no status, we again ordered you to show cause. We ordered you to show cause why sanctions should not be imposed against you individually for ignoring our May, September, and October orders. We directed you to respond to our order to show cause in writing within 5 days. Those 5 days came and went. We received no written response, and on January 5th, we set this matter for hearing. A few questions before I allow you to say whatever it is that you want to say, counsel. How long have you been admitted to practice law in the state of Florida?
Since 2002, Your Honor.
Do you have a disciplinary history?
Not that I don't believe so. I think I got censured one time, maybe 10 years ago, but other than that,
What was
nothing.
that for?
That was for an advertising um, matter.
Okay. Um, and do you represent these particular individual appellants in their bankruptcy proceedings?
I did not, Your Honor.
Who does?
James Harper.
What is the status of these bankruptcy proceedings?
They are discharged, Your Honor. I filed earlier this morning a status report indicating that the three bankruptcies were discharged, two of them on August 6th, and the third one on August 12th of this year, Your Honor.
What efforts, if any, between yesterday and when those bankruptcy matters were discharged, did you make to speak to bankruptcy counsel to apprise yourself of what the status of those bankruptcies were?
I spoke to James Harper yesterday and asked him for copies of the discharges, and he sent them to me yesterday.
Is that the first time? When was the last time before yesterday that you spoke to Attorney Barker?
Harper, and it would have been I was seeking status from him on the bankruptcies. It would have been before August, sometime in summer. I was asking him where he was in the process, and he advised that he was having an issue with one of the three, but obviously he resolved it.
What steps, if any, other than the status report that you filed this morning and for what it's worth hasn't hit our docket yet, at least not that I've seen, to move these appeals forward?
None, Your Honor. I was waiting to learn that the bankruptcies were discharged. And honestly, Your Honor, I just missed the orders that were emailed to me that you mentioned. And to be frank, Your Honor, I missed the order for today's hearing as well. I got a call yesterday from your clerk, Stacy, and I called her back immediately, and she thanked me for calling her back, and I said I should be thanking you for calling me because I missed it. I wouldn't have been at this hearing today, Your Honor. Those orders are going to the correct email address, but I closed my practice some time ago. I'm an in-house counsel now to a corporation. And so this is an old relic case from 2017. I closed that practice in like 2018. And this matter came basically one of the last two or three cases that I had to try to finish out. And so I don't regularly check that email address. And I'm just glad Stacey called because I wouldn't have made this hearing and I would have been in real trouble. I'm not making excuses. I'm just letting the court know how this could have happened. There's no excuse for it whatsoever. And I take full responsibility for it. As I mentioned in the status report, the intention of the bankruptcies was to discharge the debt associated with the judgment. That has now occurred, and the intention of the appellants is to dismiss this appellate action as quickly as possible. I spoke to one of the three appellants yesterday. He confirmed he's in agreement to do that. I reached out to a second one, and he has not returned my call yet. But I've spoken to all three of them about the intent here on the bankruptcies and the appeal, and the intention from the beginning was that if the bankruptcies went through and were discharged, the appeal would be dismissed as well. I will add one more thing, Your Honor. As this was an old case of mine, I was really diligent at the time when the judgment was entered, and in that 30-day period to inquire from the clients what their intentions were, whether one appeal or not. They told me no, 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 up until the last day when they changed their minds and said, we want to file an appeal. And I was flabbergasted and had this really scurry and file this thing as quickly as I could. They did not pay me for it. They didn't pay my costs that I forwarded for everything that I did. And I told them I was going to have to withdraw. And that's when they decided to file the bankruptcy with Mr. Harper. So this has been a disaster for me personally, Your Honor. At this point, I'm upside down on every which way possible, and now to receive this order to show cause is humiliating. I've never had an order to show cause against me before. I apologize for wasting the court's time. I've never willfully disobeyed or ignored a court order before, and it sure looks like I did here. And I didn't, Your Honor. And the fact that I didn't know the hearing today, and I got that call, I'm just glad you called them. So there's no excuse for it. But that is exactly what happened, and I will accept whatever punishment the court gives me.
So I appreciate greatly the candor and the acceptance of the responsibility. I can't speak for the rest of the panel, but it helps me. And I know you're referring to the name that perhaps that you were given, but the person who called you is Stacy Pechtel, who is our clerk of court, who oversees our clerk's office. You've got three judges who've convened a sanctions hearing because multiple orders were not responded to that were received. This, a decent amount of time and resources has been expended in getting ready for this. So acceptance of responsibility aside, have you given any thought as to what an appropriate sanction in this case might be?
I haven't, Your Honor. I realized this yesterday, close to 5 o'clock, and I did not think about what appropriate sanction would be, Your Honor. Apologize.
It's okay. Judge Smith, do you have any questions for Attorney Calzada? And I think you're muted, sir.
Yeah, Mr. Calzada, we do appreciate you taking responsibility, certainly. I guess a couple questions that I have. When you got the initial order from our court, I assume, did you get the initial order from our court, the one that stated that we needed a status update within 120 days?
I went back and looked, Your Honor, and I think I received 3 separate orders requiring me to file something within 10 days, 2 of them, and then third one within 5 days. So they hit my account. They hit the email address. There's no doubt about it. Okay. They didn't go to junk. They were in the inbox.
Did you, going back to that May 2025 order, the one where we said, tell us what's going on in the next 120 days, when is the first time you saw that particular email?
Yesterday. When I talked to Stacy, I began doing keyword searches, and that's when my heart sunk.
Okay. And I assume when you initially filed the appeal back in November timeframe 2024, at that point you were watching your emails to ensure that it was properly filed.
For sure. Yeah, for sure. No, I checked it to make sure it got filed. I called the clerk's office. I for sure did all those things to make sure that it was timely filed.
And you mentioned, and I just want some clarification on this. You mentioned that you were shutting down or shut down your practice in the 2017 to 2018 timeframe. Is that correct?
In 2018, up until 2018, I had a robust practice here in Central Florida. I took an in-house counsel job summer of 18 in Colorado, and basically, I won't say close it down. The LLC is still active, but the practice itself was shut down as I took this in-house counsel job.
Okay. And as of 2024, the end of 2024, how many cases did you have left at that point?
Off memory, less than 3.
Okay.
Were
any of those cases in an appellate status?
None whatsoever. And that's kind of what threw me off, that the email section is different for the appellate court than it is for the courts that the other cases were in. And so I wasn't picking up that these were coming from a court, and that's my mistake. I think I've only filed one appeal in my career, and that was probably 10, 15 years ago. This is only a second one. I'm not an appellate attorney. And again, I only filed this one because I was given no choice at the last minute by the clients. It was a defensive filing to protect my license.
All right. Thank you. I don't have any other questions.
Judge Kamouzis, do you have any questions?
So just to clarify, you filed the notice of appeal in November 2024 with one email, and is that right?
It's that I used the same email.
From your prior practice?
Correct. It's the same email from the prior practice, and I still have that email open and operational. It's just not something that I regularly check.
Okay. And since 2024, November 2024, did you check that email account?
I have checked that email account on a number of occasions since that time frame. Yes, I have.
Since November, but
And in fact, I know that I received emails regarding this case because I had to file additional documents after the appeal was filed. That's when I was cognizant this was happening and was looking to see what I had to do to move the appeal forward. Then the bankruptcies were filed, the automatic stay was issued, and it just went on the back burner. So I wasn't actively looking like I should have.
Okay, because you did get and receive the request to provide a status update within 120 days. You did receive that.
I received all of everything that was emailed to me regarding the case is in my inbox, all of them.
But I think just so I can understand and make sure I understand your answer, for the May 14th, 2025 request for the status update within 120 days, when did you first see that? Was that yesterday or around May?
Yeah,
Okay,
yesterday is when I went back and found all of them. I just went back one December and then October, November, then October, and then May, and I'm like,
okay, I don't have any other questions. Thank you, Judge.
Is there anything else that you want to say, counsel, before we recess?
I think I've said it all, Your Honor. I would never willfully violate or disregard an order. I know it looks like I did that here. I didn't. There's been no prejudice to the clients, which is the most important thing. And I apologize to the court for wasting your time. Whatever you need me to do, I'll be happy to do it. I'll do some pro bono work for people. Whatever you need me to do, financial, I'll do it. I'm in the wrong, and I accept responsibility for it.
All right. Thank you, counsel. We'll take the matter under advisement and we'll issue an order, and we're in recess.
Thank you, Your Honor.